Very good evening to all of you. So, I am Vikas Verma, former Assistant Advocate General and Co-Chairman of All India Lawyers Forum. So, I am moderator of this session. So, I am pleasure to welcome to this webinar. So, firstly, I would like to welcome Shri KTS Tulsi, Senior Advocate and Member of Parliament Rajya Sabha. And we have another keynote speaker, Shri Jayant Kumar Shur, Additional Solicitor General and Senior Advocate, Supreme Court of India. And today's our knowledge partner, Professor Ajay Thomas, Director, Faculty of Law, Manav Rachna University, and Dr. Karuna Akshay Malviya, Principal, MGM Law College, Mumbai. Today's our media partner, SSC Online and latestlaw.com. And we have another guest, Vinod Kumar Goyal, Chairman, All India Lawyers Forum. So today's topic on the plea bargaining and criminal jurisprudence. So may I request to Professor Ajay Thomas kindly deliver your introductory remarks in the respect of our guest. Over to Ajay Thomas.
Mr. Verma, thank you very much. Ladies and gentlemen, Devior Sajjano, a very good evening to all of you. And at the outset, I must say that I am delighted and indeed honored to be asked to be giving this opening remarks, for which I must thank Mr. Vikas Verma, co-chairman of the All India Lawyers Forum, and also Mr. Vinod Kumar Goyal, who is the chairman of the All India Lawyers Forum. Brevity is the soul of wit, they say, ladies and gentlemen. And therefore, on that note, I shall try to be as brief as I can with my opening remarks. As mentioned by Mr. Verma, my name is Ajay Thomas, and I have the great honor of being the director at the Faculty of Law at Manav Rachna University. And the university is delighted to be a supporting partner to this exciting webinar being hosted by the All India Lawyers Forum. Now, many of you in the audience might not know much about the Faculty of Law at Manav Rachna University, and I do not blame you for that, because we are a very young law school located in the Aravali Hills in Surajkund on the border with Delhi and Haryana, and we are just into our third year of operations. We offer 5-year integrated LLB honors programs and also an LLM and PhD program. The university is a foundational member of the LSAC Global Law Alliance, which is a group of 11 of India's leading private law universities. Ladies and gentlemen, I must make a very candid admission out here at the very outset. The topic for today's webinar, plea bargaining and criminal jurisprudence, is a very interesting subject given its very recent entry into Indian criminal law jurisprudence. But at the same time, I must say that it is something which is very remote from my area of specialization, which is international commercial arbitration. And therefore, ladies and gentlemen, I shall leave all the substantive remarks to our most learned panel of speakers. And talking about panel of speakers, we are greatly privileged today to have with us a superstar cast of speakers, which includes a man whose name is synonymous with criminal law in India, and secondly, a youngish senior advocate who has the tough task of representing and defending the government of India in the Supreme Court every day. And that is indeed a very onerous responsibility. So let us look in detail at each one of us distinguished speakers. Our first speaker is Mr. KTS Tulsi, who most of you know is a senior advocate and a member of the Rajya Sabha. He was born in the year of India's independence. Mr. Tulsi graduated in political science honors from the Punjab University and completed his bachelor's in law in 1971 and started his practice at the Punjab and Haryana High Court since that year. In his initial years of practice, Mr. Tulsi, in addition to being a lawyer, very interestingly, was also a part-time lecturer in the law. And it was during this period that Mr. Tulsi wrote and authored two books, and I must say two very popular books, one on motor accident claims and another on landlord-tenant disputes. From 1980 onwards, Mr. Tulsi gradually drifted into the field of criminal law on his appointment as a special prosecutor in the states of Punjab, Delhi, and Assam. In 1987, Mr. Tulsi was designated a senior advocate, and in 1990 he was appointed an additional Solicitor General of India, in which position he represented the Union of India in several important cases, including the case involving the constitutional validity of TADA, the Bombay Blast case. In 1994, Mr. Tulsi was elected as the President of the Criminal Justice Society of India, a position which he still holds today. Ladies and gentlemen, I can go on and on with Mr. Tulsi's bio, but due to paucity of time, all I can say is that we are very, very honored and distinguished to have a man of Mr. Tulsi's eminence to be on this panel of speakers today. Our second speaker for today, ladies and gentlemen, is Mr. Jayant Sood, who currently serves as the Additional Solicitor General of India. And as I said earlier, he has a tough task of representing the government of India in India's apex court basis. Mr. Sood has served as an additional Advocate General of Punjab in the Supreme Court and is an elected executive member of the Supreme Court Bar Association, an election which he won with an unprecedented huge record margin. He has appeared in and argued in a lot of landmark cases before the Supreme Court of India. So, ladies and gentlemen, on that note, I'm reminded, and I also remember an old saying which goes something like this: if you want people to like you, speak a little. If you want people to like you a little more, speak a little more. But if you want people to like you the best, shut up. On that note, it's over to you, Mr. Vikas Verma. Thank you very much for this opportunity to deliver these very brief opening remarks.
Thank you, Mr. Ajay Thomas, for giving the wonderful remarks in the respect of our guest. So now may I request to our keynote speaker, Sri Ketis Tulsi sir, kindly deliver your speech on the topic of plea bargaining and criminal jurisprudence. Sir, over to Ketis Tulsi sir.
Well, thank you very much, Vinod Kumar ji. I am very grateful to Mr. Vikas Verma, Professor Ajay Thomas, Dr. Karuna Malviya for inviting me and giving me an opportunity of being able to propagate the plea bargaining system, without which the criminal justice at least has completely broken down. Justice system by itself also has come in for a lot of criticism by jurists, and it has variedly been called the cancer of delay, which has crippled the judicial system. It has variedly been suggested by judges, lawyers, politicians, jurists, law teachers that criminal justice system is in the ICU. It itself is in the intensive care unit. It is virtually paralyzed. This paralysis of criminal courts and of police stations give free hand to the criminals. We have a very high rate of growth of crime. It makes crime low risk and high profit business. Law ceases to be a deterrent, and corruption scandals involving politicians and others they continue galore. Let us see, because the best justification for plea bargaining is the delay that takes place. And it is the delay which was sought to be reduced to the minimum by introducing a new chapter on plea bargaining. Please have a look at this Supreme Court from 2000 to 2015, or more than doubled the pendency. Starting from 21,000 cases, now it's about 54,000. The High Courts from 2000 was to the tune of about 28 lakh, and now it's 42 lakh. The pendency in the subordinate courts in 2000 it was 2 crore, and now it is 2.7 crore. Well, we are still whipping the statistics of 2015 because the National Crime Record Bureau refuses to release the latest statistics. If we look at the areas, it is National Crime Record Bureau says that the number of cognizable criminal cases pending trial in 2015 were 1 crore 55 lakh. Cognizable criminal cases were there in 2015, and the total crimes that were registered in 2016 were 20,97,000. The crime rate comes to 379 crimes per lakh population. India is the fourth most dangerous country for women, as per the Global Peace Index of 2017. And their report is in the Financial Express news report dated 23rd February 2018. The trials which were completed in 2015 were 46,99,145. That is about 30%. And 60% were further added to this burden in the next year. Now, if you see the mounting areas, till April 2018, 3 crore 53 lakh cases were pending across India. And out of these, 86% were pending in the subordinate courts, 13.8% pending in the high courts, and 0.2% pending in the Supreme Court. Between 2006 and 2018, up to April, the pendency before the Supreme Court increased by 36%, and by the High Court by 17%, subordinate courts by 7%. These are shocking statistics. More than 1 lakh rape cases are pending. To be exact, 1,30,195. These are the figures of 2015. More than 1,70,000 murder cases pending. More than 4,60,000 cases of 498A. Since when are they pending? We don't know. There were some statistics which have become obsolete, and the latest ones are not available. But the problem is that these rape cases, murder cases, many of them could be pending for the last 10 years. They could be pending somewhere or the other for 20 years, 30 years. The other day I did a case where the High Court took 34 years to dispose of a criminal appeal. Now, that's not justice. If we are not able to deliver justice and we won't give bail at the same time, it's double whammy. I'm today not talking about I'm not talking about bail, but let's look at the crime clock. One crime is committed against woman every 2 minutes. A molestation takes place every 12 minutes. A rape every 22 minutes. A dowry death, you can't fake it. Death is death. A dowry death every 61 minutes. A young girls being burnt in their own house is a shame on society. 498 a case every 5 minutes, sexual harassment every 53 minutes, kidnapping and abduction 23 minutes, one robbery occurs every 21 minutes, a murder committed every 16 minutes. The violent crime occurs in India, one crime or the other, every 2 minutes. Well, friends, these are not happy statistics. Our prisons are packed with under trials. The total capacity of Indian jails is 366,781. The total number of inmates, 419,623. Indian jails are abominable. It is hell on earth. It is worst punishments that the law can inflict. The number of under trials out of 419,000 is 282,076, which means 67.22% inmates of our prisons are under trials. That's also a shocking and shameful statistic. The conviction rate. The conventional system in which conviction rate is calculated is number of persons charge sheeted to number of persons convicted. But that's wrong. I like to take the statistics of number of persons arrested and number of persons convicted. That means those who were arrested and not convicted, either not charge sheeted or not convicted, they also suffered. They suffered incarceration sanctioned by judiciary. And therefore, I like to calculate how many persons arrested. Under the Prevention of Corruption Act, for an example, 66,657 persons were arrested. 3,690 were charge sheeted. The trial was completed for 29,920. 13,803 persons were convicted. And the persons who were acquitted, 29,591. Conviction rate of 31%. In most civilized countries, conviction rate is in excess of 75%. There are countries where the conviction rate is 99%. I don't know why it doesn't happen. One of the reasons is we haven't understood the art of plea bargaining, and we haven't been able to utilize the provision which was added by way of a special chapter. Conviction at all India level for persons arrested in IPC cases is 37.2%. This is the conventional system by which the by which the conviction rate is calculated by the NCRB. 34.66% arrests were made in bailable cases. Why? Why arrest in bailable? They could have been, but a poor man has no right. A poor man perhaps has no constitution. 28% cases are pending investigation, and 79.6% cases were charge sheeted by the police. This is all in percentage. We've taken whatever data is available from 2015. Now we come to 2006. One of the difference between India and the liberal countries where we have the same Commonwealth common law system, they all have plea bargaining. Even Africa has plea bargaining. They say that we don't promise perfect justice. There is no foolproof justice. But the system must work. In India, we say the opposite. We say that no, we must continue our effort towards perfection. Whether the system works or not is not our headache. So this is the chapter, and I am very sorry to say that the spirit of this law has been missed by the bar, by the bench, particularly the trial courts, where this was supposed to be utilized. The system, the methodology has been worked out in detail in section 265 capital A. And it says that the chapter shall apply in respect of accused against whom a report by the police has been filed under 173 or a complaint has been filed for an offense which is not punishable with more than 7 years. So plea bargaining at the moment is available only for offenses which are punishable with less than 7 years, and definitely not possible that in the case of life imprisonment or death, it would be applicable. The second condition for taking advantage of plea bargaining is that the magistrate has taken cognizance of the offense other than by way of a police report. Now, again, the same condition that the plea bargaining can take place in complaint cases also, but not for offenses which are punishable with more than 7 years. The government, by notification, has also been authorized to determine the offenses under the law for the time being in force and shall be the offenses affecting socio-economic conditions of the country. Section 265 capital B provides the mechanism of plea bargaining. It says that the accused may file an application for plea bargaining. Please note the terminology. Accused may file an application for plea bargaining. Plea bargaining doesn't mean confession. And yet I have seen myself in courts that wherever the accused says that I want to bargain, the court says, iska confession likho. So we haven't understood the difference in the mechanism that has been provided in this chapter. The mechanism does not require confession. The defense lawyers don't use it thinking that it will require confession. The prosecutors will not allow plea bargaining unless there is a confession. And that's where this whole law has been misunderstood. A brief description of the application is required to be supported by an affidavit by the accused that he has voluntarily preferred that application, and the second condition that he has not been convicted before. Second, any offense by the convicts who have been convicted, the plea bargaining is not available. The next is that the court is required to issue then a notice to the public prosecutor. The court shall examine the accused in camera. At that time, there is nobody else, not even the prosecutor, but where the other party in the case shall not be present. So this is a confidential meeting between the accused and the court in camera, so that he can, without any The court has to satisfy itself that the application has been made voluntarily, and therefore, before the prosecutor steps in, the court asks questions for being able to satisfy that the accused is not under duress. The public prosecutor thereafter is given a notice to work out mutually satisfactory disposition. It's not confession. And that's the bane, that we haven't understood the difference between mutually satisfactory disposition is that you can bargain, but the report will only say that mutually satisfactory disposition because it does not disqualify the accused who has availed of the plea bargaining. It does not disqualify him from being a government servant, from being a voter, for being able to contest for an election. It's an honorable punishment which may be already undergone or may be reduced. The court has all kinds of methods of being able to arrive at a mutually satisfactory disposition. If the court finds that the application is voluntarily made, then and also is satisfied that he's not been previously convicted, it proceeds further in accordance with the subsequent provisions of the code, and that is 265 capital C. The guidelines are laid down in the statute itself for mutually satisfactory disposition. In a case instituted on a police report, it shall be a notice to the prosecutor or the police officer who investigating officer, and also the victim of the case can participate in that meeting to work out a mutually satisfactory disposition. So once the court arrives at the conclusion that it is voluntary, and he then says that the accused, if he so desires, can participate in that meeting between the prosecutor and the victim. If the case is instituted otherwise than police report, that means complaint cases, the court can issue notice to the accused and the victim of the case to participate in a meeting and work out mutually satisfactory disposition. Now there are two provisos, that mutually satisfactory disposition of the case that is completely voluntary, and second, that the victim may participate in such meeting with his pleader engaged by him in the case. 265 capital D is the report of the mutually satisfactory disposition submitted to the court. And under this provision, the satisfactory disposition has been worked out. The court shall prepare a report of such disposition, which shall be signed by the presiding officer of the court and all other persons who participated in the meeting. And if no such disposition has been worked out, the court shall record such an observation and proceed further with the trial in accordance with the provisions of as if nothing happened. Then the 265D-B says that a case instituted otherwise than police report follows the same procedure. The court is only concerned that it should be completely voluntary and that the victim also was enabled to participate if he so desired. 265 capital E is disposal of cases. How do the case get disposed? This is one chapter which is in great detail considering this, and perhaps the lawmakers are far more ambitious and hopeful that it will succeed, but up till now it hasn't. The court shall award the compensation. It can award the compensation to the victim if it is part of mutually satisfactory disposition. In accordance with the disposition under section 265B, and here the parties on the quantum of punishment, it releases releasing the accused on probation. If it is covered by the Probation Offenders Act, he can be released under the probation offenders. He can also be given the benefit of Section 360 CRBC. So this is an enabling provision in addition to whatever provisions were there, and not a substitution thereof. 265B says that the Probation Offenders Act, under Probation Offenders Act, if that is applied, he can be released. And the court released on probation on promise of good conduct. 265C is a very important provision, and nobody knows about this, unfortunately, not many. After hearing the parties, the court finds that the minimum punishment has been provided in the law. It may still sentence the accused to half of the minimum punishment. You know, we spend so much energy and effort in going to the court for being able to get bail. And we never utilize these proceedings, under which the accused can get huge benefits and also be able to get secure release. And 265D provides that if the court finds that the offense committed by the accused is not covered by clauses B or C, it may sentence the accused to 1/4 of the punishment provided or extendable, as the case may be. 1/4 of the sentence. This is really a revolutionary provision that has been enacted. And finally, the judgment in the court under 265F has got to be delivered in open court. It has to be signed by the presiding officer in the open court. It is an express provision, lest anybody thinks that this is a private junket. The Section 265 capital G provides for finality of this judgment. There is no appeal. There is no review. There's nothing that anybody can do, and except for the writ petition and Article 136, which are the powers of the constitutional courts, nobody can take away. 265H specifies the power in plea bargaining of the court. The court shall have, for the purpose of discharging its functions under this chapter, have all powers vested in it in respect of bail, trial, and other matters relating to disposal of cases. So if the disposition does not take place, in that case, the powers could be utilized for going ahead with the case in a regular fashion. 265L gives the benefit to the accused that whatever sentence he has undergone under Section 428, the setting off is in addition to the benefit conferred on the accused by this chapter. So minimum can be reduced to half. Where the maximum sentence is there, 1/4 can be awarded by the court if it so likes. And then also whatever he has undergone, the benefit will be given to him under Section 428 of the Criminal Procedure Code. There is saving provision under 265J gives it an overriding effect on all other provisions. Every other provision will bend to enable this provision to have a complete play. Wherever it touches, it overrides the normal law. In the statement of accused made in the course of these proceedings or proceedings under this chapter, if they have not been able to arrive at any consensus, then the statements made earlier cannot be used for convicting him, cannot be used as evidence against him. Those statements were made only, those are privileged statements, and they do not come to the aid for the purpose of trial of the court trial of the case on merits. This chapter does not apply to juveniles or children under Section 2K of the Juvenile Justice Act. And plea bargaining in other countries, let us see, plea bargaining is deemed to be a prominent feature of the American criminal justice system from 1920 onwards. By 1980, almost 90% convictions in the United States are obtained through guilty pleas. We don't even have to have plead guilty. So our system is far better. The American criminal justice, they say, would have collapsed if plea bargaining was removed from it, because there are so many moral issues which are raised. But they say that it will crash. But criminal justice in India perhaps has already crashed, and we desperately need this provision. In Brady's case, it was held that the system, plea bargaining, was constitutionally valid. And the Brady versus United States, they say that merely because he entered into an agreement out of fear does not illegitimize a bargained plea of guilty. So the US Supreme Court upheld it even when there was a fear which entered. Because if you are trying to get out of a death sentence, the fear factor operates, but it does not illegitimize a bargained plea. That is what the US Supreme Court said. In 1969, the US Supreme Court again, James Earl Ray pleaded guilty to assassination of Martin Luther King Jr. to avoid execution of death sentence. And he finally got imprisoned for 99 years. In the judgment of Bodenkircher versus Hayes, the US Supreme Court says that there is no element of punishment or retaliation so long as the accused is free to accept or reject the prosecution offer. I think that the same would apply to India, and wholeheartedly. The plea bargaining in other countries, particularly in poor countries, the plea bargaining is often criticized due to involvement of coercion, threat, or undue influence, which deteriorate the outcome of justice system. But about 88% of the nations have accepted plea bargaining, or in one form or the other, as an alternative dispute redressal system. The plea bargaining statistics in India, only 0.45% of cases under IPC were disposed of on plea bargaining up to 2015, from 2006 to 2015. Out of 1 crore 5 lakh, 50 lakh cases under the IPC were disposed of by the courts on plea bargaining. Total cases were 1 crore 5 lakh, but plea bargaining were 4,816 cases. According to Hindustan Times report in 2015, there are about 4,000 cases of murder, robbery, and crime against women, which were disposed of by courts in 2014. But I cannot accept that because, firstly, the report doesn't say the plea bargaining. And plea bargaining per se does not apply to cases where punishment is 7 years or more. So therefore, in India, virtually it is non-existent, 0.45%. Thank you very much. I only hope that in the days and the years to come, we learn to make use of this important weapon that we have, and that's the only way, according to me, by which we can revive criminal justice system and make it sufficiently prompt. Thank you. Thank you.
Thank you so much, sir, for giving the deep
Thank you.
knowledge about the criminal law, basically plea bargaining. Uh, Now, may I request you, Jayant Kumar Sood, another keynote speaker, kindly deliver your speech on this topic. So, over to Jayant Kumar Sood.
Thank you, Vikas. First of all, I would like to thank the AILF for inviting me and also express my warm regards to Mr. KTS Tulsi, our esteemed member of the Supreme Court, Member of Parliament, Rajya Sabha, Professor Ajay Thomas, Director, Manav Rachna University, Dr. Karuna A. Malviya, Principal of the prestigious MGM Law College, Mumbai, the audience and members for participating in the session. And I would be not out of place to say that I would want to personally congratulate Mr. Vinod Goyal and Vikas Verma for an excellently organized, conceptualized topic. The ALIF, as I'm told, through various mediums, has brought about awareness on legal issues of relevance among the legal community, the law students, and also general public. Today's topic is of plea bargaining and criminal jurisprudence, which is a very interesting choice and, my opinion, highly relevant in today's time. The topic is well chosen and quite relevant today. A recent order that was passed by the Delhi court has become a part of a public discourse wherein plea bargain provided under, as mentioned by Mr. Tulsi, 265A to 265L of the CRPC were sought and allowed in relation to the Talbigi Jamaat matters. And the heading that went on in the newspapers was Court allows 98 Indonesians to walk free on payment of fine under plea bargain. Now, what was the tenor of reporting was of the use of the word walk free, which probably implied that there was something alien to the procedure prescribing being done. What was done by the trial court, in fact, was a lawful exercise of power as per the statute. Though through today's lecture, I will explain how plea bargaining has various advantages which can be successfully used and may lead to fulfillment of various objectives of criminal jurisprudence and the penological theories. I am reminded of a case quickly that I was doing a case for extradition of a fugitive from India to Canada who was a participant in an international drug cartel extending from Afghanistan, Pakistan, Myanmar, and Bangladesh and India. The leads of the investigators pointed out this gentleman living in Mumbai. He was, on a basis of an extradition request, arrested by Mumbai police, brought to Delhi, where the extradition court was set up. Now, using all the legal weaponry that he had, he was able to extend his stay and the proceedings under the Extradition Act for at least about 3 years. And the Canadian government was in an absolute limbo, not knowing what to do, because the trial in Canada against the other accused, which are more than 50 in number, was going on. So, after consulting with their authorities, a couple of officers of the Canadian government, which had sent the extradition request, came to India. They had an interview with the accused, the fugitive, and were able to prevail upon him that if he consented to his extradition back to Canada, they would probably offer him a plea bargain. And plea bargain in a case of such a nature where narcotics is looked at very seriously all over the world. But he took the deal. He consented to the extradition. He went to Canada. He entered into a plea bargain. And what he was given was actually about 4 years of total sentence. And in that period of 4 years that he was awarded, even the 3 years that he had spent in this country were set off. So, in effect, he was back in India after committing a crime of this nature, thankfully not in India, but towards another country, and came back easily. Now, the plea bargain that he entered into was entered into with the view that we don't want to keep somebody who doesn't belong to this country. We don't want to sort of keep him in our jail at our cost. And it came back. So that's an example, a classic example of what I could think of, as was also mentioned by Mr. Tulsi about the American jurisprudence and the American percentage of conviction and all. Now, coming back to criminal jurisprudence is nothing but protection of society from apprehended or competing wrongs. And all criminal laws enacted in this regard come within the scope of criminal jurisprudence. Penological jurisprudence looks at the theories, which are very well recognized theories over time, all the countries, is rehabilitation, deterrence, incapacitation, retribution, and proportionality. While justifying punishment and its objectives and goals, plea bargaining as a concept satisfies all their goals of penological jurisprudence. Plea bargaining is, I would say, rehabilitative. It ensures that the accused gets a lighter sentence, and the objective being reformation, he reforms and integrates into the society rather than spending long periods of incarceration in jail or courts. Plea bargaining is also in line with the notions of proportionality and retribution, which refer to the ideal that the victim should get justice by ensuring that the punishment should be proportionate to the wrongdoings committed. In fact, plea bargaining ensures this because it envisages that the victim or complainant has a say in the process, and at least in India, has a large degree of control in the amount of compensation that may be decided and whether the plea should be accepted or not. In fact, plea bargaining is also a welcome step. It ensures that justice is swift and certain rather than delayed and prolonged. Going through a full blown trial, appeals, process, they take a long time, decades. So it's not only that the accused or the victim suffers, this justice system also gets clogged, towards the end of which the witnesses gets frustrated, uninterested or hostile, and legal process takes a toll also on the complainant. Any eventual conviction is a procedure providing for the cutting short this protracted trial, and it also deters future offenders from committing crimes. It instills the faith of the society, which largely comprises of law-abiding citizens, as I would say. Thus, I would put it that plea bargaining is not actually an act of condoning a wrong committed both against the complainant or the society. The complainant and the accused providing both effective resolution, swift resolution, while simultaneously avoiding costs and efforts involved in the ordeal of a full trial. The accused, complainant, or the state or the courts are all to be satisfied. It is an effective mechanism for reduction of the pendency in the courts, which is the reason why the lawmakers promulgated it and the amendment was brought. In fact, plea bargaining was never a part of the Indian system. It's only when some recommendations were made by the Malayamat Law Committee Commission in 2001 that it was recommended. Our courts, that even the apex court, was very, very apprehensive of it to sort of introduce the amendment. But the amendment did come in 2006. And rightly said so by Mr. Tulsi, it's a concept that we have actually adopted and originated in the US legal system, where startling figures that Mr. Tulsi gave of conviction and all the plea bargain cases did not reach trial or go through the ordeal of calling for a jury, collecting of evidence, and other things. The US model needs to be adopted on a basis wherein some of the salient features of their code for plea bargaining are very interesting. And I request Mr. Tulsi also, who is our lawmaker, also to make such suggestions to the parliament, because I'm told there is already a commission of reforms on criminal law that is sitting and is considering all such suggestions. I will also be forwarding, and I'd also request Mr. Tulsi to do it. Now, the US model works on a couple of stages, but three very prominent stages on which it works is a stage where there is a chance for the accused to do a sentence bargaining. The accused can plead guilty in exchange of a promise by the prosecutor to recommend a lighter or an alternative sentence for the same offense. The next is also bargaining for a charge. The accused pleads guilty in exchange of the promise made by the prosecutor to reduce or dismiss some of the charges brought against him. The third important, which Indian perspective I think, is that the accused pleads guilty in exchange for the prosecutor's promise that certain facts will be excluded from the trial, which would mean the omitted facts would have increased the sentence, and hence an omission reduces the sentence substantially. And for example, I would say the fact that certain quantity of prohibited substances were seized from the accused, which quantity could have triggered a graver punishment. Now, the whole system, as has been also come to fore now, needs some bit of training and changes. Now, the first change I think what we would probably be looking into is that the lawyers are often unaware and apprehensive of taking up the plea bargaining route. Since the first thing in the line of defense that we as lawyers and criminal lawyers especially are taught is false implication, the defense of false implication. Innocent till proven guilty. And there is a lot of stigma attached with plea bargaining, because the accused has to plead at the very initial stage. That is where he has not even understood what the charges are against him properly. But as for comparing it with the US system, it provides three options to the accused: guilty, not guilty, and the third one is nolo contendere, meaning I do not wish to contend, which would mean that the accused does not accept or deny the charges but agrees to accept punishment. Now, all this fits in very well into the Indian system. I mean, the apprehension, we really don't know, because there is no clarity or law on that part, that you go and you plead guilty, you move an application of your own vocation, which is determined to be voluntarily moved, determined as voluntary by the court, and tomorrow it ends up in a conviction, and what effect does it have on your future prospects is also something which has to be taken care of. The accused might plead, after pleading guilty, the enigma would be that his plea bargaining still may not be allowed. For instance, that if the court finds that it is barred, or if no mutual satisfactory disposition is reached between the complainant, accused, the police, and the public prosecutor. Then the third aspect is the use of plea of guilt in the same or other proceedings, as I just said. Lack of authoritative pronouncement would probably, or a pronouncement would probably set the matter to rest. As a result, a lot of lawyers simply advise their clients to compound the offense, which they consider is a better option. Or maybe after some time, settle with the complainant, go to the high court, get a FIR quashing order done, and rest in peace. But I personally feel that there are several advantages of plea bargaining. The fact remains that the plea bargaining advantages now need to be encouraged by courts. Judicial and prosecutorial resources will be conserved for those cases in which there are substantial issues at stake. The advantages of plea bargaining for the accused and limiting the probable penalty are obviously, namely, I would say his exposure is reduced, the correctional process can begin immediately, the practical burdens of a trial are eliminated. But all this can happen once there are some procedural safeguards in our system. The system in place currently has various procedural safeguards which ensure that plea bargaining can be free and fair. So, where I would say that the judge, as a judge, should play a proactive role, and he should make sure that the accused is acting completely voluntarily, of course, but he should also apprise him, and that there is no coercion, there is no settlement of any other nature in this matter. Then the accused alone can take the initiative to move the machinery for plea bargaining, leaving no scope for inducement from prosecution. Scope of corruption is reduced in the system because of this increased participation of the victim complainant, who has a say in the quantum of compensation and negotiation. Moreover, I think in the present system, there is no bargaining at all between the prosecution and defense, since there will be no prior assurance to the accused, and the judicial mind will determine the sentence at the end. Serious crimes are removed from the ambit of the plea bargaining entirely is also a positive sign, I would say, but they would need to amend it accordingly, because the nature, kinds of offenses, the acts that are coming in are also providing for different punishments and would need a revision from the government. So, taking a cue from the fact that we have a timeline that we are on, I would like to conclude that the practice of plea bargaining is highly desirable and part of the robust and effective criminal justice dispensation system. In order to increase the reliance on the same, I have a few suggestions for all of us to carry forward. It is, we need detailed rules for plea bargaining. I have not come across any rules for plea bargaining, either by the courts or by the government. So these rules should provide for a modalities of how the mutual satisfactory disposition may be reached. Otherwise, it's in a gray area, and depend on the consent, it might tomorrow never reach. The rules also need to provide for safeguards such as separation between a judge overseeing plea bargaining and the judge dealing with the trial. This will help in overseeing the plea bargaining uh, process. Uh, I think the trial judge, by keeping an eye on what's happening, would should not get prejudiced by it. And in fact, it should be a different judge, completely a different judge, who should deal with a plea bargaining application. And that report, unlike a mediation report, should not even go to him. Further, I personally think, because we need to sort of make reforms like this. So right at the start of the proceedings, when we send a summon to an accused to come and appear, the summon itself should carry a sort of a declaration or a note or a reminder that you can finish all this immediately if you want. Don't even really need to go to a lawyer. You just come to court. We'll give you a lawyer, just like the mediation process, because that's all going to unclog the whole judicial system. Uh, there should also be, my personal view is, a institutional framework, just like mediation is there in family courts, conciliation is there under the Arbitration Act. Uh, we need to promote plea bargaining in criminal cases where punishment is under 7 years or maybe more. That's for the lawmakers to decide. So another issue which plagues the system is that even after filing a plea bargaining application and reaching a mutually satisfactory disposition between parties, the court still has the discretion to allow a reduced sentence, which is the word used in the statute is may, not shall. So it's again back to the discretion of the court itself. Some proper training for the judges and lawyers, uh, officers of the court, and above all, I think a judicial pronouncement is needed for for us as lawyers, as prosecutors, as law officers by the court to simplify it and encourage people, encourage litigants, encourage lawyers to go in for plea bargaining. Lastly, I think most of the offences up to 7 years come under people who are who commit crime, maybe not because of a profession, but maybe because of compulsion or circumstances. And it has happened so many times that the under trial prisoners have undergone one fourth or half of their maximum term, and thereby recommend them. No, I mean, thereby just by recommending them for release under for on bail under 436A of the court would not really solve the purpose. 436A is where half the sentence has been undergone. The court will release him on bail. But rather than that, where it has reached wasting time on bail, he's already undergone. Please go. We are letting you go. So overall, and I know I'm keeping a tab on the watch. Overall, I'm optimistic that this is a practice that can be fairly incorporated in our legal system successfully, even within the narrow parameters that are provided for. That I think so, and this will lead to not only increase in conviction rates and disposals, but also decrease under trial prison populations while respecting the basic rights of the accused, as was done in the Talbigi Jamaat. And I'd end my views by saying this that Mr. Tulsi, we have absolute trust in you. You are a parliamentarian. We hope these will reach the parliament and something. Thank you so much. Thank you for having me over.
Thank you so much, Jen sir, for giving the academic and procedure knowledge about the plea bargaining. And this knowledge definitely would help for the lawyers and as well as the academians also. So now we have the some questions. So sir, may I ask one question? Ravinder Singh from the Delhi. That sir, may I ask? Okay.
Because I'll just be able to answer one or two because I have to rush for another
Perfect,
one.
sir. Perfect. Okay, okay, sir. Perfect. So this question is the whether accused can withdraw the application once filed by him. If yes, till what stage?
Well, my answer will be that we can withdraw till the time it does not reach the judge for consideration after the mutual meeting for between the parties has taken place and it has in principle been agreed as to what the compensation will be and to what the punishment will be. After all that is decided and it goes to the court to consider, then it's not possible. My view is it is not possible. The court will not permit you to withdraw it.
Okay,
So
sir.
can
Thank you so much, sir. So I think Tulsi sir, I think have left. So now you are in a hurry. So may I request to Dr. Karuna Akshay Malviya kindly deliver your vote of thanks in respect of our guest.
Sure, sure. With great, yeah, sure, sir. With great privilege and pleasure, I take this opportunity as a principal of MGM Law College, Navi Mumbai, and on behalf of All India Lawyers Forum, to extend our gratitude by way of vote of thanks to both the respected speakers, respected Senior Advocate of Supreme Court and the Honorable Member of Rajya Sabha, Mr. KTS Tulsi ji, and respected Dynamic Senior Advocate of Supreme Court, Mr. Jayant Suchi. Respected sir, we are obliged and very much fortunate to hear you both in this webinar. Your expertise in delivering the legal principles is highly appreciating, sir. The opening remark made by respected Tulsi ji about our prevalent criminal justice system will definitely give an alarming signal to our participants and motivation through the corrective measures for its eradication. The practical and current examples of plea bargaining cases quoted by respected Jayant Soodji is notable. The practical analysis done by Sir on criminal jurisprudence and comparison with the US model and the suggestions and recommendations proposed are really notable, sir. So we are very fortunate and very much thankful that you accepted our invitation and you gave your valuable time and motivated our participants. We extend our thanks to all the participants and congratulate them for participating in this webinar. We extend our thanks to our knowledge partner, Manav Rachna University, as well MGM Law College. I personally thank all the principals of University of Mumbai for encouraging the participation of their students. I also take a special opportunity to thank the organizers for their collaborative work with us and for organizing this great event. An event like this cannot happen overnight. It requires planning and a bird's eye for details. We have been really fortunate to have a team which is a motivated and a dedicated team. And I take this opportunity to mention the support team name individually. Our National Executive Chairman, Mr. Vinod Kumar Goyalji, we extend our thanks to you. The National Executive Co-Chairman, Mr. Vikas Vermaji, President, Mr. Abhinav Singh, National Coordinator, Mr. Suvir Sidhu, Vice President, Rashmi Bansal, Secretary, Vikram Dharma and Naveen Gupta, Treasurer, Mr. Balraj Puri, our National IT Head, Mr. Manvendra Sharma, Foreign Division Coordinator, Ms. Pragya Parijat Singh, our Academic Division Coordinator, Professor Dr. Mohit Sharma. I extend thanks to all the staff, state coordinators and presidents. For Delhi State, Mr. Sandeep Garg. For Punjab, Mr. Bikramjit Singh Jatana. For Chandigarh, Mr. Amandeep Singh Manse. For Haryana, Mr. Udit Mendiratta. For Jharkhand, Mr. Dipesh Kumar Nirala. For UP, Mr. Sagar Sharma. For MP, Mr. Dharmendra Kumar Malviya. For Andhra Pradesh, Mr. Anil Kumar Jaldi. For Gujarat, Mr. Bhagyoday Mishra. For Jammu and Kashmir, Mr. Furqan Sofi. For West Bengal, Miss Jahan Arakulsum and Suvjit Ghosh Dastidar. For Odisha, Mr. Jayant Kumar Padhi. For Maharashtra, Mr. Durgesh Gupta. For Rajasthan, Ms. Swati. And for Tamil Nadu, Mr. Chandrasekhar. Our special mention to our media partners, latestlaw.com and SCC Online. And definitely not last but not the least, our student wing coordinators, Mr. Shubham Singhal, Ms. Riya, and Ms. Bhagyashri. And to all other members of the forum whose name, if I may have missed to mention. Thank you so much.
Thank you, ma'am. Thank you very much, and thank you all the participants who are watching this live session. We are very grateful, and we are very soon coming with our new latest session with the new learning sessions. I hope you enjoying this session and you learn something more with these sessions. In a short period, we are trying to teach you. We are trying to share the valuable views of our seniors. Thank you very much. Thanks, sir. Thanks, Vikas ji. Thanks, Ajay ji.